What was at the fore before us is the question of whether the High Court has the power to upset a decision of this court, whether under Section 18 of the Constitution or on any other basis. This matter originated from the High Court, and it has had a number of twists and turns, some quite misconceived, if I may say so. At the High Court, the appellant was charged with a number of criminal offences, of which he was convicted. And he was sentenced to a number of punishments constituting a suspended sentence, and on two, he was fined with the penalty of imprisonment in case of default. He appealed to this court against conviction. When the matter came on appeal, it was heard by a 3-member panel. The appeal against conviction failed, was dismissed, and the court, being of the view that the sentences imposed were inappropriate, and after having heard the parties on the issue of enhancement of sentence, they enhanced the punishment with an effective custodial sentence of 7 years, which was for the major offense. The appellant, believing that there was a statement in the decision on sentence which showed that the court, and I think in quote, was pandering to the desires of the executive, the president as the executive, approached the High Court, contending that his right to a fair trial, enshrined under Section 10(1) of the Constitution, had been infringed. The matter came before a panel of 3 judges at the High Court, and at the commencement, an application was made for the recusal of a member of that bench, Kiwanang J, on the ground that there was a reasonable apprehension of bias. His brother and his mother having benefited from some of the proceeds from the monies, the subject matter of the transaction which led to the charges against the respondent in this matter. The 19JA refused the application for recusal, and the panel proceeded to hear the merits of the Section 18 application. The decision by a majority was that this court had violated the respondent's constitutional right to a fair trial on the basis of the alleged statement. And that majority proceeded to set aside the sentence imposed by this court without any further order, meaning in effect that it was the decision of the High Court which now stood. The third member, while agreeing that the constitutional right of the appellant had been violated, was of the view that the best approach and was to refer the matter to this court to decide what to do. The appellant has brought this matter on appeal, leave for an expedited hearing having been granted by Morupi JA. One of the twists and turns that arose was that the respondent applied for a recusal. Firstly, of the whole panel, on the ground that the President of the Court of Appeal had improperly empaneled the bench, she having an interest in the matter. And secondly, a recusal of 2 members of the panel on the basis that they had dealt with a matter involving Marsland, who had applied for a review of the DPP's powers to prosecute him. When the matter came for hearing, the matter regarding the President of the Court of Appeal was abandoned, and the respondent then filed another application, this time for a stay of the hearing of the appeal, pending the hearing of a review application to be instituted in the High Court, reviewing the decision of the President to empanel the bench to hear this appeal. Both the recusal application and the stay applications were summarily dismissed by this court with the reasons to be furnished today. After hearing the main appeal, this court has reached the following decision. The law is quite clear, both on the provisions of the Constitution and the hierarchy of the court, and on decisions of this court in previous matters, that this is the apex court of the land, and that the High Court, as a court which is subordinate to this court, does not have any power to interfere with the decisions of this court, even under Section 18 of the Constitution. The question which arose, which the respondent urged upon us, was that if we did not agree with him, and if we found that the High Court did not have the power to interfere with the decision of this court, we should adopt the approach which was taken in the case of Attorney General versus Mawu, and consider the matter ourselves, even though it has inappropriately come before us, and find that the High Court was right in the event, insofar as the alleged infringement is concerned. We have considered that, and in our view, Mawe was wrong in that when the High Court doesn't have the power to entertain an application, it should not enter into it, and that it is only this court that can, under exceptional circumstances, revisit its own decisions. We have, however, considered that because this matter has now come to the fore and has been topical, we should consider and indicate whether in any event the respondent had made a case for an infringement of the Section 18 rights. And we find that it hasn't. The decision of the High Court was of this court at appeal stage was quite clear that the court considered the law, it considered the facts, and there was only one sentence upon which the applicant, the respondent, held on to as a straw to try and challenge a decision which was on its own clear that it was not based on any outside influence. On the merits that the appeal cannot stand, we have also now provided the reasons for the refusal of the recusal application and the application for a stay. These reasons will also encompass whether or not Kivonan J was correct in refusing to recuse himself. This is because the law of recusal is common to all this, and the law is quite straightforward. The presumptions in favor of impartiality of the judges is a well-trodden field. We have found that in respect of the intended application for review of the empanelment, that is misconceived. The president of the court did not act in any way other than in her professional capacity as president of this court in a matter which has got no personal interest and on which the empaneled court was going to be dealing with a purely question of law. As regards the recusal of the two judges, being myself and Dambe J.A., the Masland case had nothing to do with the present case. It made no reference to any conduct in relation to the respondent, Mr. Morupisi. It was purely on a question of law as to what grounds, on what grounds a decision of the DPP to prosecute can be challenged. When one looks at the number of decisions we referred to in this judgment, it's quite clear that that was a long shot on the part of the respondent. It was for that reason that the recusal on the basis of the Masland case could not stand and was summarily dismissed. In respect of the K19J recusal, the facts are different. The allegations there, which were undisputed, were that both his brother and his mother had benefited financially from monies which were part of the transaction which directly deals with the conduct of the respondent. In our view, that was a matter in which a reasonable person looking at the facts would have wondered whether K19J could fairly and impartially consider the matter. We had also postponed for determination today the question of the cost of the application for a stay. That we have determined, and in our view, the heightened cost, scale of cost which the appellant sought is not appropriate in the present circumstances. So the order of the court is as follows. 1, the dismissal of the application for a stay of these proceedings is confirmed with costs on the ordinary scale. 2, the dismissal of the application for the recusal of the 30JA and WJA is confirmed with costs on the ordinary scale. 3, the respondent will pay the cost of the application for an expedited appeal on an ordinary scale. Those costs had also been postponed to the main appeal. 4, the appeal succeeds. The order of the High Court is set aside and replaced with the following. The application is dismissed with costs.